Hi, everybody. Thanks so much for joining us. And welcome to this third event in our 2020 International Animal Law Speaker Series. The series is co-organized by two international animal law ABA groups, one co-chaired by me, the other co-chaired by Dana Bray and Joan Schaffner. A special thanks to both of them for helping to coordinate and advertise this event. I'm going to paste our contact information and affiliations into the chat, just in case you'd like to know a little bit more about our groups, how you can join or otherwise get involved. And if you don't wish to join, but would just like to be added to an email list to be apprised of events such as these, just send me an email to that effect by using my email address, which again, I'll be pasting into the chat here in a moment. Just to note that we'll be taking questions at the end of Jane's talk. So if you can mute yourself until then, if you aren't muted already, to cut down on background noise, we'd very much appreciate it. With that said, I'm honored to be able to introduce Jane McElligot, who will be discussing pet custody and divorce cases on an international scale. Jane is a legal studies professor at Purdue University Global. She earned her BA in history from the University of Massachusetts Lowell, her JD from Suffolk University Law School, and her MSCJ from Kaplan University. And I should also note that Jane is a certified humane education specialist and serves as the chair of the animal law section of the Idaho State Bar. Thank you so much, Jane, for sharing your presentation with us. And with that said, I will turn it over to you.
Thanks so much for having me. It's an honor to be part of this. And so my topic on pet custody divorce cases, looking at it on an international scope, I can't believe all of the the case law and articles on this topic. So it's quite an interesting topic to delve into. And just as any other type of law, when you look at it comparatively, you really get some good ideas on how our country can go with this in the future. So I'm just going to talk briefly about pet custody law in the United States, just sort of summing up how we approach it, and then we can compare that with the approach taken in I chose Israel, Switzerland, Italy, Canada, and the UK just because there's a lot written on those countries. But again, I think this could be something where if I had another month, I could have found all the countries. But some countries there just isn't too much on because it's just the traditional property law approach. I'll also talk about pre-pup agreements and petimony and dog napping instances. And I had to feature two of my own little ones there at the beach. So if we look at pet custody law in the United States, there's really three approaches that are taken by the courts, or now that we have three new statutes in place in California, Illinois, and Alaska. There's the traditional approach of pets, personal property, same as a TV or sofa, inanimate objects. There's a kind of a step up from that where some courts look at pets as personal property plus, so more than property, and the court will apply what they refer to as a best for all concerned test. So it's not quite best interest of the pet, but they will not go ahead and order, say, joint custody or visitation. And then finally is the most progressive route, where some courts and some of the statutes are pointing to it, the idea that we look at the pet's best interest and also have the opportunity for the court to apply joint custody and even visitation. So the traditional approach really is summed up in some of the case law, really cold characterization of pets as personal property, the same as a lamp or table or TV set, and not entitled to anything beyond their pure economic value, which of course for many of us with a rescue dog, it's not going to add up, even though it's the world to us. So this really cold-hearted approach was best summed up by a New Jersey Superior Court judge. Dogs are chairs, they're furniture, they're automobiles, they're pensions, they're not kids. So really laying it out there. If we look at, for example, community property states, California, Idaho, the court ownership of a companion animal is typically determined by looking at who paid who paid for the pet, was just kind of who paid that adoption fee, or if it was a puppy that was, expensive, who paid for that initial cost of the pet. So really taking that strict property law approach. One of my favorite cases is Travis versus Murray. And this is a case that really illustrates that middle tier approach where it was property plus, really pretty close to best interest of the pet, but it was more along the lines of best interest for all as the court referred to it. But and I think I can, well, I won't mess with it, but I was going to make that a little bit smaller so you can see the whole slide. Maybe I can try that. Let's see. Yeah, I won't mess with it, I'm afraid. So in Travis, the Supreme Court of New York, of course, the trial court in New York, actually held that there would be a full hearing for custody of this pet. And at the hearing, the parties were pretty much given a list of questions to come forth and discuss. And the dog at issue in this case was Joey, a little miniature dachshund. I have a picture of him on the next page. And at the hearing, the judge said that each former spouse would discuss, how why she would benefit from having Joey in her life, and why Joey has a better chance of living, prospering, loving, and being loved in the care of one spouse as opposed to the other. So really looking at the interests of all concerned. And so the judge mapped out the questions, who bore the major responsibility for meeting Joey's needs, who fed Joey, who walked Joey. So really looking at that primary caretaker approach that we look at, in a child custody case. Who spent more time with Joey, so maybe the psychological parent coming into play there. There is Joey. And so the court in this case, it did note that it was hesitant to apply a best interest of the dog standard, so it wouldn't quite go that far. But clearly, we can see the court was recognizing that dogs are far more than just mere property. And so pet parents in this, according to this ruling, have the right really to come forth with evidence to prove, why it would be in Joey's best interest and their best interest for them to have custody. So really a cutting edge kind of decision in that case. The court in Travis said, and this is a great decision to read too, just because the judge had a good time talking about dogs, and you can tell he really had a lot of respect for dogs. And in fact, he had a footnote in the case saying that, full disclosure, I have a pit bull who can leap buildings in a single bound, and went on that. But noted that no matter what one may think of treating our dogs like people, whether it's humanification or personhood, or endowing dogs with human-like qualities, it is impossible to deny the place they have in our hearts, minds, and imaginations. And I think this is really what we see as some judges who are willing to step up and say that in a court decision, and pretty much pushing the higher courts and maybe the legislature to take action on this. And the court in Travis, they pointed to another case from the Wisconsin Supreme Court, Rabideau, where the court said that we're uncomfortable with the law's cold characterization of dogs as mere property. Labeling a dog property fails to describe the value human beings place upon that companionship that they enjoy with a dog. And pointing out that a companion dog is not a fungible item equivalent to other items of personal property. So the case law here, and even though we still, for the most part, follow that traditional route, you can still find some good cases where the judges are talking about that important bond. So another case that Travis pointed to was Houseman versus Dare, New Jersey trial court decision. And this was precedent setting too, because the court applied the contract remedy of specific performance. The it was former girlfriend, boyfriend. The boyfriend had promised to give the dog to the girlfriend if anything should happen. Um, they ended their relationship. He didn't give the dog to the girlfriend, so then she sued, saying asking for specific performance, and the court granted that relief. And the court also said that, recognize this special subjective value of dogs, because they had to point to, that a dog is unique, of unique nature, in order to grant the remedy of specific performance, and pointed to that strong sentimental attachment between a person and a dog. Um, so really and the third approach, the most progressive of all in the United States, is the approach that when the judge uses discretion, which of course family court judges have a lot of discretion. And so in doing so, they're really, even though they may not use the words best interest of the pet, you can tell that's what they're doing. Just some examples: Texas court named one spouse the managing conservator of the dog, and really good quote that we are sure there is enough love in that little canine heart to go around. And love is not a commodity that can be bought and sold or decreed. Um, Love should be shared and not argued about. And a Texas appeals court also had a visitation plan for pets. For Bonnie Lou, pointing out that Bonnie Lou is a very fortunate little dog with two humans to shower upon her attentions and genuine love not frequently received by human children from their divorced parents. So really a lot of equity being applied by these judges. Another example: Maryland court did a 6-month period of rotating 6-month period of custody, so both parents could pet parents could enjoy time with their aging Maltese. Alabama actually did use the term the dog's best interest, and they cited to the Alabama um, animal protection statute, which is interesting. Another one of my favorites is the one on Lovey the cat. This is a case where this was Raymond versus, I have the site in the back, I think it was Raymond versus Lackman. It's in the references in the back, but it was a roommate dispute over a cat that they had bought. And the court fashioned a very equitable resolution, pointing to that the cat was a little older, 10-year-old cat, and they found that the cat really liked where he was living. So the court said that we're going to allow Lovey to remain where he has lived, prospered, loved, and been loved for the past 4 years. And the owner, the supposed owner of the cat who left, actually had more of a ownership right. So the court clearly rejected just pure property law, and instead said, even though they didn't use the term best interest of the cat, that's really, it's pretty inherent in the decision and the discretion used by the judge. Just a quick run through the 3 statutes we have now on pet custody too. So Alaska became the first state in 2017 to put into place legislation that requires the courts to take into consideration the well-being of the animal, and they empower judges to assign joint custody of pets. And then a year later, 2018, Illinois, the second state, and in that state, courts are again required to take into consideration the well-being of a companion animal in divorce dissolution proceedings. And also, this legislation orders courts to grant sole or joint ownership of the responsibility for companion animals, and empowers the courts to create joint responsibility agreements to resolve custody disputes. So we're starting to see a lot of movement in the legislature, um, legislative action on this. And then California, of course, January 2019, clearly differentiates companion animals from other types of marital property. And of course, California being a community property state, and it empowers California courts to take into consideration the care of the pet animal in cases of marital dissolution. And so before that statute went into place, animals were treated as television sets and cars. And so courts were just to equally divide the property. But under the new law, courts have authority. They're not required, as we see in Illinois and Alaska, but they're empowered to create shared custody agreements for companion animals and enter an order requiring a party to care for an animal prior to final determination of ownership. So while the dispute is going on, the court can issue a temporary order. Um, so that sort of wraps up the kind of a summary of the law in the United States. So the first country I compared U.S. law with is Israel, and so of course there's more case law in this country involving animal-related issues, um, just because we have more laws on animal protection and all of this. So the courts in Israel have not traditionally been a place for animal rights issues, but that's changed in recent years. So in 1994, Israel passed the Israeli Welfare of Animals law. And so since that, more cases have rolled in, and really the courts there have become much more proactive in animal rights issues, including custody issues. So one of the outstanding cases from Israel is Plani versus Planet, and which just means John Doe versus Jane Doe um, in Israel. So this judge shows, I think it shows say, um, of this one particular family court in Israel applied a good of the animal test and actually cited to American law to the case. I think I have it cited on the next slide here. Um, it was the case, the Corsi case that I have coming up in another slide or two. Um, but Jane Doe and John Doe, the parties in this case, so they were in a common law relationship. And during that time, they rescued and raised a blind cat that they named Jane Eyre, and an ailing dog, and the dog recovered in their care. So when the relationship ended, the wife left the household. She took her share of the marital property and she took the two pets with her. The husband started filing all these complaints against Jane Doe. And one of the things he was requesting was joint custody of the pets. So he wanted equal time with the pets. Or he said, if not that, then he wanted the pets to be separated. He gets one, she gets one. But she responded saying, no, I'm the sole provider of these pets. And she also alleged that the husband was just using the pets to kind of get leverage and get more property. So the court applied, and this is just a trial court, again, discretion of the judge, but applied the good of the animal standard and actually heard evidence from a expert on animal behavior, and reached the determination that custody should remain with the wife in this case. And just to look at a little more of the evidence in this case, um, one of the issues that we'll see in a second is that the expert actually pointed out that the cat was dependent on the dog. So because the cat and dog were so close, closely bonded, they should remain in custody with the wife. So the parties in Plani, they weren't the ones arguing for a switch from the traditional property law grounds, but it was the judge who announced that he would take this different path because, as kind of weighing the evidence, it just occurred to him that this is just property law just doesn't fit. And so he said that in his decision, and he said really that traditional property law fails to provide the legal system with tools to adjudicate and resolve the petitions for custody of companion animals, and bring to a suitable solution. And the judge noted that it's more constructive to consider companion animals as family members. So really, I mean, seems clear to us, but this is pretty landmark decision. Um, and I love the language that this judge used, referring to animals as creatures with a soul. And saying that creatures with a soul should not be viewed as things, shouldn't be viewed as a TV or sofa. But he did kind of qualify that a little bit by saying that um, they shouldn't be viewed as equal to rational beings. But that's true in the sense that while we want rights for animals, we recognize that animals, aren't going to vote, for example. So not a bad comment there. So this was the case I mentioned that the judge in Pawnee cited to support really his creatures with a soul designation. Corso versus Crawford Dog and Animal Hospitals. Interesting case, not a divorce case, but a case where the dog's person, the guardian of the dog, it was a poodle who had passed away, and um, the owner wanted to have a respectful funeral for the dog, and she looked it turned out that the animal hospital had actually given her a cat instead of her own dog, and she saw this, and it was just a case of extreme emotional distress. And so in that case, the court talked about how important, that connection between a person and a pet is, saying that a pet is not just a thing that, not just a thing, but occupies a special place somewhere in between a person and a piece of personal property. So interesting that the court pointed to that American case as precedent, really. And so in applying the good of the animal standard in Pawnee, the judge recognized the needs of the cat and the dog, and evaluated, which party is most qualified to meet their needs by listening to the animal behavior expert. And again, that expert pointed out that actually it was the dog. I was thinking at first, I was thinking of it as the cat was being dependent on the dog, but it was actually the dog who had this very strong attachment to the cat. And so therefore they should remain together. So the good of the animal standard really does, go beyond similar cases in the United States, in the sense that, maybe equivalent to some of those very progressive state cases in the United States, but the court here is really clearly considering the animal's best interest. Um, it just wouldn't admit, sort of similar to the ones in the United States, it won't admit that it's veering from the pure property law approach. So the evolving case law that we see both here and in Israel, it is suggesting that we're, on this verge of a shift in resolving pet custody disputes. And really this step away, it's taking a while, but eventually, this step away from viewing animals as property, to recognizing their own interest, as sentient beings, really. So, and it's so essential given the unique nature of pets as living and sentient, and those emotional bonds between pets and their carers, really. Um, the one of these uh, this article written by the person who was examining the law in Israel, Rook, and again, I have all the references at the back here, but this person argues that because animals have interests, so of course, interest not to be abused and interest to be treated kindly and all of that, and have these strong, special relationship with their carers, a test unique to pet custody disputes that borrows theoretical tools used in child law is essential. So really arguing that we need to use something similar to best interests of the child standard, the ones that are going to apply, because that really does provide this suitable framework. Some things aren't going to fit, for example, education or religion. That's not going to fit with a pet, but so many of these same factors do apply. Um, and points out really that animals are like children, innocent and defenseless, and it's imperative that courts consider that, their well-being, their safety when making custody determinations. So hopping over to Switzerland, Switzerland has some interesting laws. In one of these articles, Article 651, it added to its civil code, ensures the interests of the pet will be the focus of resolving pet custody disputes, when there is this what's referred to as shared ownership or joint ownership under Swiss law. Under this article, it instructs the court to grant sole ownership of a jointly owned pet to the party that, with regard to animal protection, ensures the better keeping of the animal. So that's their phrase. Instead of the best interest of the animal, which one can provide the better keeping of the animal? So notice though that there's not the emphasis that we see in the statutes in our country on, hey, let's have joint custody. It's more pick out the one who is the better caretaker and give custody to that person. But clearly the court's focus is on what's in the best interest of the pet. Where is the pet going to thrive best? So this determination, it looks at not only the physical needs of the pet, which one will walk the dog, or which one will be sure to bring the dog to the vet, but also the psychological well-being of the pet. So the legislative materials in Switzerland, of course, this is a civil law jurisdiction, so it's all types, loaded with codes and regulations, more than case law, really. But the legislative materials there specify that the key factor to be weighed by the court is the relationship between companion animal and human caregiver from the animal's perspective. So really to be analyzed exclusively in the animal's interest, which is pretty amazing. And so that standard aligns with Switzerland had put into place what's called the dignity of the creature provision. So it clearly saying that animals are not objects, and it's actually they're not to be demeaned. So this one law review article was actually pointing out that dressing a dog in silly clothes could actually be a violation of the dignity of the creature provision. So very protective of the respect that we give to animals. So the animals are not objects provision, it doesn't create a new legal status for animals in Switzerland, but it certainly does give this strong message that Swiss law recognizes animals as sentient beings, not just like a car or a chair, for example. So the Swiss animal protection provisions are part of the factors that judges are to consider in custody. And one is that social animals shall not be kept alone. So this is really interesting that it specifies which animals are social, and especially points to guinea pigs, rabbits, saying that they need a social partner of the same species so that they're, for their emotional well-being. And so, you would think that, okay, if a couple's divorcing, they have two rabbits, well, each gets a rabbit. But the courts in Switzerland says, no, those rabbits have to be kept together because of their emotional needs. So clearly looking at the best interest of the animals there, and not of over the spouses, really. So other factors the courts look at, they look at the environment of the party, so the age, the health, mobility, family situation, living quarters of both the people and the pets, the financial situation of the party, so which one can afford to take care of the dog or cat, and the strong emotional attachment to one of the parties, and or household pets. So again, like in the other case, if there was, say, a cat and a dog and they were attached together, then attached between themselves, that would be a strong factor. Or maybe a dog or a cat is closely bonded with a child in the family. So those are all factors to consider. So once the court issues its decision under the law in Switzerland, that ends the joint ownership, and then title vests solely in the party deemed by the court as the party who ensures the better accommodation of the animal. So it's still kind of a little bit of a property law. It's not totally custody law, so we still see remnants of property law in place. But so it becomes sole title in one, and really that other spouse loses all rights to that pet or time with that pet. So the court has authority to order the party who attains exclusive property of the animal to actually pay the other party indemnification. It's not a set standard on how much indemnification. It's left to the judge's discretion in applying the principle really of just equity. Um, so because the courts do allocate sole ownership to the spouse who's deemed more suitable, the spouses are really incentivized there to reach some amicable property agreement, and the court will recognize that as valid, because still there is that, kind of mix between property law and recognizing dogs as and cats as different from regular property, but still a little bit of that mix between property law and sentient beings. Um, so there is always that kind of push for the parties themselves to come to an agreement. As far as patrimony goes in Switzerland, Switzerland follows really this, the push to have this clean break theory that the former spouses should be the end. They can go on and live their own lives, support themselves. But the court does have authority to order one spouse to pay the other spouse maintenance if their financial situations, the other party needs that help. So there's different categories that the court has in determining how to award maintenance, and the care for the animal traditionally has been more in sort of like a little hobby, like a cultural interest. Um, but there's a strong argument, and some courts have gone this way to say, no, caring for the animal should be a basic social need, because we are close to our dog or our cat or other um, companion animals. So there's that need that if one spouse can't afford to care for that pet, then the other spouse should be ordered to help pay maintenance for that. And one court has agreed with that approach. A court in one Swiss canton, as they're referred to, ruled that maintenance costs for animals should be automatically included in the monetary support one ex-spouse has to pay another. So hopefully that's a trend that will keep going in Switzerland. So switching to Italy. So under law in Italy, animals are afforded in general a status really similar to that of inanimate objects, and really their custody is determined along the lines of property distribution. But again, we see this approach that may be moving to it a much more positive direction. So there have been recent innovative rulings that show this approach, that really animals are respected as sentient beings with important interests of their own. And probably the best example of this is this case in the Civil Court of Rome. This was 2016, so not too long ago. It was a dispute over a family dog, and the court pointed to, there's really kind of complained about the lack of legislation, because again, we're looking at a civil code jurisdiction, and the legislature really hasn't taken the action needed when it comes to pet custody. So that the judge opted to adhere here to the legal principle according to which the legal regime for minor children shall apply to pet custody. So in the judge's words, mutatis mutandis, the Latin for things being changed that have to be changed. So apply the best interest of the child standard, but then change, when we come to education or religion or something else that doesn't fit with dogs and cats, make that change. So really a innovative decision there. And so by following the legislative approach for custody of minor children, the judge shifted the whole perspective. So it's looking at the point of view of the dog. So it's the dog who is the one who counts for the protection of the dog's interests, not which parent wants the dog. So the judge voiced his disappointment really with the legislature there of not passing legislation to deal with pet custody, saying that the delay of the legislature in recognizing evolving human attitudes to animals and pointing out that this legislation is necessary to protect what he referred to as the material, spiritual, affective interest of the animal. And so we really see in our country and in other countries this, powerful movement by judges speaking out for the animals, really. And the judge here recognizes that the animals, as sentient beings worthy of respect, need that protection of the court, of the law, and really sheds light. His decision really sheds lights on the possibility of the courts being the ones to bring about the cultural shifts driving the evolution in human attitudes toward animals. So there's hope, hope in, oops, I think I skipped one. Sorry about that. So hope for Italy too. Looking at Canada, we kind of see the same thing, sort of the overall kind of, traditional approach, but then some hopeful rulings. So Canada, again, continues to view pets as property. When it comes to custody, visitation, it only applies to human children, not furry children. So one of the rulings in a Nova Scotia case, this Gardner Simpson cross, really sets forth this traditional view that emotion notwithstanding, the law continues to regard animals as personal property. There are no special laws governing pet ownership that would compare to the way that children and their care uh, are treated by statutes on family law. And so sadly, the court is saying there are not laws that dictate that an animal should be raised by the person who loves it more or would provide a better home environment, even though it's clear those laws are needed. So really the same old school approach in Canada. And so lawyers there encourage guardians of animals to enter into, they tend to use the word pet nups to arrange matters, ahead of time if something should happen, which one gets the pet, or arrange a joint custody arrangement. But there's some positive notes in Canada. So one is that Quebec passed legislation that specifies that animals are sentient beings rather than inanimate objects. That was geared more to it helping in the field of animal welfare, but clearly that could help apply in pet custody cases as well. Interesting case in British Columbia too. This was 2017, Brown versus La Rochelle, where it's pretty clear the court considered the best interest of the dog, and the dog is because of the dog's breed and the loyalty. I have a slide on the next, a picture on the next slide. There is a Jindo, very cool looking dog, kind of like a husky, but they're known to be very loyal and bond very strongly with people. So because of that, the judge found that this dog had cemented a bond with the wife in this case, and the dog was jointly owned from the very beginning. The parties, could prove that they bought the dog together, and so, but um, really this case stands for this idea that, if the parties can show that the dog is jointly owned, the courts will consider the breed, specifically the characteristics of the needs of the pet, which would provide for the pet given its needs. And could, in this case, there wasn't a joint custody arrangement just because the judge found that because of the dog's breed, he's better off staying with the one and not going back and forth. But clearly could have ordered joint custody in this case, given the discretion really that the judge was using. But pretty interesting that the judge in this case was actually pointing to the particular breed of the dog as one of the factors. You don't see that I haven't seen that in the cases in this country. Oops. In the UK, really still following the traditional approach of pets as personal property. It continues to rule, and because of that, the law firms there in the UK are pretty much push people to enter into either, kind of a pre-pup agreement, or if they don't, go for arbitration, because at least in arbitration the law firms will offer these services where they'll apply the best interests of the animal test that's very much aligned with the best interests of the child test. And so the arbitrator will look at, the capability of the parent to look after the child, just substitute dog for their for that for the child, and the likely effect of a change in circumstances. So many of the same factors would come into play. So because courts in so many states in this country and in other countries still tend to follow this traditional approach, mediation is often highly recommended, because a mediator can form a arrangement that's going to work for the pet, for both parties, really a guardian plan that takes in the best interest of all into account. And really the guardians are going to benefit because, just as in child custody arrangements, if the parents can have a say in, when they want custody or visitation, it always works better. Everyone feels like they're playing a role in it. Same thing with pet custody. The guardians, can kind of come up with what schedule is going to work for them, what is going to make their companion animal most happy, because they know themselves and their pet too. Um, so one other thing I noticed in looking at the law in England is a significant rise in dog napping or dog theft cases. And in fact, there's the link on the bottom, this dog listener website. It's really shocking the number of thefts, how it's risen in recent years. And, sadly, situations where these dogs there was on that website, he has this video of this one woman talking about how she let her two dogs out in the backyard, fully fenced backyard with a gate. Well, she just went, for a brief errand. She came back and the dogs were gone. And she hasn't, I think she's been searching, I think it's 3 or 4 years. She just searches everywhere for them, nowhere in sight. And, they're saying that these dogs are stolen. They are either sold to others for profit. They might be even sold to, for as meat in that industry, or of dog fighting. So, it's such emotional upset uh, for the people whose dogs are taken, not knowing where they are. So really, the public is upset by this, because it's the laws or the punishment for dog theft just doesn't reflect what has been taken away from a person. It's not as if someone stole your wallet or or car. So there's a push to make pet theft a separate crime in the UK that recognizes this difference and really recognizes that pets are sentient beings. So if that comes about, perhaps that's a way too to push for better or more discretion that judges can use in pet custody cases as well. So I think advances in other areas of the law for animals will apply to pet custody as well. A little more on pre-pup agreements. That's my Yorkie in a stroller, relating to children. So a pre-pup agreement is a clause in a prenup agreement. Of course, it could be a whole separate agreement as well, but it's really that vehicle that serves as a way to avoid disputes over pet custody. And it can address all types of issues, whether it be custody, visitation, care responsibility, vet bills, and all of that. There's a link down there too, that has it's a really a good site because it has the law in each country on the enforceability of prenup agreements. And of course, it seems as though pre-pup agreements should follow along with the same guidelines. Can check that out. And just a little quote from Travis versus Murray that speaks to divorce cases in custody. People who love their dogs almost always love them forever, but with high divorce rates, but with divorce rates at record highs, the same cannot always be said for those who marry. So that is it. And I do, if anyone would like this PowerPoint too, I do have a bunch of references to. There's really excellent law review articles on this topic, many just focusing on one particular country, whether it be Switzerland or Italy. So lots out there to kind of get ideas for, as to how our country could approach it. So thank you very much.
Thank you so much, Jane, for that wonderful presentation. As you were speaking, you might not have been able to see these, but we've had several questions come in from the audience, and I'll go ahead and start with Deborah's. She asks, why does it need to be all or none? The pets do not necessarily hate the ex. This also enables caretaking between two who can share pet and expenses. Just wondering if you had thoughts on that.
Yeah, well, I think that's so true. And I think it does, it reminds me of child custody cases where, one maybe doesn't really even want custody of the child, but is really kind of using that child as a pawn. And I think sadly, we do see that in pet custody cases. And I think that's really speaks to the advantage of the, a pre-pup agreement or mediation to resolve that. If both do really love the pet, it does seem like they can easily work something out. So yeah, thank you for that.
Thank you. And then Cheryl asks, as I work on these cases and in my legal research, I'm curious how the pet industry case law compares to ownership disputes and legal title. How do they relate to one another or differ?
Yeah, I think really we do see that it is a combination that we see in all these cases that I think until the law just says, pets are this different category, I think until that happens, we're always going to sort of see that legal title come into play, because in the traditional approach, it seems to be that the way the judge decides is, okay, who paid the adoption fee, or who, paid that price when the dog was a puppy, and that's the way they decided, as pure property. And that just, of course, is not right, given that it might be the other spouse who does all the walks and spends all the time. So I think it's really the more progressive courts are the ones that are going to, where the judges are applying just their decision, or in the states with the statutes saying, focus on the well-being of the pet. I think there, that factor of who bought the pet is the legal title, I don't think is going to matter as much, but I think we need that continuing evolution, really. Thank you.
Thank you. And Deborah follows up with a question. If one spouse is given the pet and the other is not allowed to share the pet, how can they be required to pay maintenance? And this might be in regard to a particular country's jurisprudence. I don't know, Deborah, if you wanted to clarify.
No, that was with respect to the program, the information you shared that said, that they'd be required to pay maintenance. Well, would they be able to see the pet or just be required to pay maintenance?
Yeah, thanks for asking that. I think that was Switzerland where I was talking about that. And it's interesting because in Switzerland, the judges there don't have authority to award visitation, but it's still a little bit iffy whether they can order the costs of raising a dog or cat, say, as maintenance, but some courts have said that the cost of the pet should be included in really the basic needs of maintenance. So it is a situation where one spouse could be ordered to pay the costs of the pet, but can't visit the pet, at least by law. So it does seem a little bit difficult in that situation.
Interesting.
Yeah.
Courtney was wondering if we could get a copy of these slides. Yeah, and if you email me, I can send you the link to this recording, the audio and video, and then the slides as well, if that's all right with you, Jane.
Sure, that'll be fine. Yeah, thank you.
And if folks have questions, please feel free to put them in the chat, or you can also unmute yourself. But I had a question for you, Jane. It's a little bit outside of the divorce context, but I think last year, Maine court discussed a case where a boyfriend and girlfriend, concerning a boyfriend and girlfriend, where the boyfriend had bought, I think, the dog, and the girlfriend was suing to get custody of the dog, but the boyfriend had clearly bought the dog separately. And I'm wondering if you'd seen any of these cases play out internationally where shared custody is given outside of sort of any question of joint ownership at the beginning.
Yeah, you know, I haven't seen it internationally, but it does remind me of these two cases I ran into where one was, well, the one sort of the Lovey versus the Lovey and Lovey the cat one. And there was another one similar to it involving disputes between roommates. So it wasn't really a divorce situation. And the court actually did override, you know, which roommate had bought the cat initially and said, no, the cat is more, you know, comfortable in this home, and they're, you know, this other person is a better caretaker. So really did override property law. But again, they kind of, the judges don't tend to admit it or make it a point that we're overriding property law, but it's kind of inherent in their decision. So I think that's kind of the really an amazing thing that we see about the discretion that judges, you know, trial court judges have, especially in divorce type cases, but even in roommate disputes, to do that and recognize that, you know, best interests of the pet should be important. So yeah.
Thank you for that answer. Jessalyn asks, I'm curious if these just happen to be the first jurisdictions that you looked at, or if you looked at sort of a variety of other nations as well, but didn't necessarily include them in the presentation due to sort of a lack of discussion in some of those courts or jurisprudence.
Yeah, that's what I ran into a lot of literature law review articles on these particular countries, on Switzerland, and I think because Switzerland is just so different and innovative when it comes to animals, and then it was just pretty much by the amount of information I could find regarding, you know, law review articles, and there's a very good one on comparing the law in the US and Israel, and then pointing to Switzerland. So that's kind of the approach I took, sort of followed the research and where it took me. But I think this is something that I would like to continue looking at this, because I think you could go on forever looking at other jurisdictions for sure. So thank you.
Carolyn asks, are you seeing the positive dicta regarding animals in these family law cases being cited in other types of animal cases, for example, cases concerning civil damages for the loss of animals?
Yeah, and you know, I think it is pretty amazing that the Plani case in Israel, the judge is pointing to that Corso case that was a tort action for emotional distress over the dog. So I do think that there is that crossover where family court judges are pointing to, you know, decisions maybe from animal welfare type cases, or maybe even you know, tort cases. So I think that and I think it's amazing too that so much of the strong wording and this emphasis to change the law is coming from trial judges, really.
Thank you. And we're coming upon the hour now, so maybe this will be our last question from Dana Bray. Fascinating presentation, thank you, and I'll echo that myself. What lessons from the other countries do you think are most helpful for advocates here in the US?
Oh, thanks, Dana. I would say that really I was most impressed with Switzerland and their approach to, I mean, putting into legislation, you know, the sentience of animals and just taking all this action to protect their well-being. I think that even they could go a little bit further when it comes to, you know, in their decisions that it has to be sole ownership to one pet parent. So even they could go further, but they seem to show, at least in the legislative realm, the most advances and really kind of the most, you know, respect for animals, to the point where, you know, their dignity, that even it could be even a violation of the law to dress them up in clothes. And I admit, I think I have put I have put a hat or two on my dog, so I have to watch the I have to watch that. But I respect, it is important, because, you know, it's so important to respect their their dignity like that. So I was really impressed with that approach, and to, you know, actually in the Constitution as well as the legislature. So I think that would be a good model to go off of.
Well, thank you so much, Jane, for that, again, fascinating and wonderful presentation, and so informative. And yes, please email me if you want a copy of the slides or of this video. I'll note that we are still looking for presenters for the next round in our International Animal Law Speaker Series. So if you're interested in giving a presentation, please email me, rajreddy@lclark.edu. And I look forward to seeing all of you again. Thank you so much for coming.
Thanks so much, Reg. Thank you, everyone.
Thank you.
Thank you.